Hello everyone. Today we are going to study about the misconduct and investigation on allegations, that is in the industrial regulation legislations. So to start with, let us start the PPT with the meaning of misconduct. A misconduct means the model standing order which specifies the terms and conditions which governs the day-to-day employer and employee relationship, the infringement of which could result in a charge of misconduct. The standing orders which provides the management with a basis for taking disciplinary action against the employees in an organization. This is very necessary if the enterprise is to function at all. The Act defines the terms of misconduct and examples are provided in the model of standing orders. In very general terms, an action or a type of behavior which can be defined as misconduct. The other examples may be go slow, which is a strike on the job, a covert sabotage affected by a conscientious withdrawal of an efficiency. So let us discuss what are the investigations or allegation. The purpose of administrative investigation is to investigate the allegations of misconduct committed by the person of an organization. On the appointed date, time fixed for the inquiry, the following person should be present apart from the inquiry officer. So, who is a presenting officer? In general terms, if a person, that is a delinquent employee, who is supposed to be allocated on a certain behavior or a matter, he has to represent that in which situation that misconduct was uh, placed and how to resolve the issue. And in this, the important person is a presenting officer. He is a person who will lead the case from the management side. So, by producing the witnesses and relevant documentary evidence in charge of the sheet, he may himself be a witness in which he is the first person to be examined. If not, the other witnesses who have seen the matter in front of their eyes and other evidence such as CCTV footage, records, video, or pictures, something. So he has to investigate all the records and evidences which are found in a matter of allegations imposed on a person. So here we see the major term, that is delinquent employee. No inquiry can be said to have been held as per procedure in the absence of the charge sheeted employee. If the employee on whom the allegation have been imposed, he is absent on the day, so there no procedure can be made on that employee when he is absent. So he has to be present in the company and in front of him should be all the procedure done. If, however, he refuses to take part in the inquiry after presenting himself, when he does not report for the inquiry despite receiving the notice which is sent to him, the inquiry may proceed to ex partes provide in the notice of the inquiry of a specific mention that effort had been made. But in this case, they have to take the signature of the delinquent employee on the charge sheet, which signifies that he himself is not willing to participate in the procedure of the charge sheet. The next one is a representative of the delinquent employee. If an employee responds to the charge sheet or a subsequent request that he should be allowed to take knowledgeable co-worker of his choice to assist him in the inquiry, which means he can have his own witnesses. So, what is the procedure of this inquiry? At the commencement of this inquiry, if a delinquent employee on whom the allegations have been imposed, he should be present, the first condition. The inquiry officer should record all the matters and place of inquiry, name of the person present, and obtain their signatures on the order sheet. The first one is in front of the employee and the other person who are involved, they should read out and explain what are the charges which are imposed on them. The second one is to explain the delinquent employee concern, like what will be the impact of those charges on him and his work position, his professional life. Then, witnesses in the support of charge. Like he has to present those members or records evidence. Like witness means a person who are present there at that time when the misconduct has been occurred and what they have seen. They have to witness it, like they have to represent those matters in front of the administrative officer. Charge sheeted workman is to give by the opportunity, like whoever is been allegated, like the allegations have been imposed, that person has the opportunity to like explain the situation on which that misconduct was occurred and how it it will not affect the company. The delinquent employee should be asked to produce his own witnesses one by one. In many cases we can see that a delinquent employee on which the allegations have been imposed, the accused person, he will say that on this particular basis or in that situation, that was the only way he could have handled the situation, so it was not his fault. In that case, to prove himself right, he have to present the witnesses one by one who can uh, justify his act on behalf of him and who are present there in reality. A concerned witness should sign on each page of his statement. There cannot be only false allegations or false witnesses and their statements. For their statement, they should justify it and they have to sign on each page of their statements. So now the next one is ex parte inquiry. On the day of fixed for the inquiry, the delinquent employee does not turn up, an ex parte inquiry may be held by following the usual procedure. If that person is not present on the date which was fixed, then on some other day the inquiry will go along. In such inquiry, the presenting officer has to lead the evidence against the charge sheeted workman. The inquiry officer, by putting those questions to the witness, can come to a reasonable conclusion about the validity or otherwise of the charges. The inquiry of report. After all the inquiry is over by the officer, he has the right to make an appreciation of the evidence on records and come to his conclusion. If there is no corroborative evidence on a particular point, the inquiry officer has to give his own reason for accepting or rejecting the evidence of such a witness. Now, what is a notice of inquiry? In very general terms, the inquiry should be normally held within a reasonable time of receiving the explanation by the parties. So, a proper and sufficient advance notice should be given indicating the day, time, venue of the inquiry, and name of the inquiry officer so that the workman can prepare his case. In certain cases, they follow the steps such as issue of show cause notice, consideration of explanation, and issue of charge sheet and notice of inquiry. While framing the notice, care should be taken not to make a statement which would indicate that the work's case has been prejudged. Like the statement that the explanation submitted was false, it should not be made in a notice of inquiry. The next one is charge sheet. As a misconduct is observed and confirmed through a preliminary investigation, a manager should frame a charge sheet which contains all the charges and description about the misconduct. And it should also ask for an explanation from that particular employee. The manager has to be very careful in framing the charge sheet because if the punishment awarded is not in consonance with the charges, the following points should be considered while framing the charge sheet. It should be properly worded and loose language should not be used. While stating the offense, date, time, place of its commission, and all other relevant details should be given. If in a frame, standing orders are in force, then the wording of charges should be in consonance with the wording in the standing order. The proposed punishment may be mentioned. and it should call upon the worker to submit an explanation in writing with a specified time or date. The charge sheet should be issued under the signature of the disciplinary authority and not the inquiry officer. So the charge sheet should be properly served. So, punishment to be imposed. This management task and punishment awarded should be based on the findings of the inquiry and past record of the employee. The gravity of misconduct should be taken into account after a discussion. If it is taken regarding punishment, it should be communicated to the concerned workman as expeditiously as possible, and different types of punishment resulting in various types of omission or misconduct, such as the oral warning, written warning, loss of privilege and fines, punitive suspension, withholding of increments, demotion, termination. Like a warning which is given in the form of oral basis, the next time it should not be repeated, or a written warning in a form of letter or a fax or email. No, like fax and email. Loss of privilege and fines. Like loss of privilege means if the employee was about to get promoted, they will not promote him. Instead of, they will keep him on the same position, and fines to be imposed. If he is fined, the accused one, he can be imposed with certain amount of fine. The punitive suspension, which means suspending the employee for a short period of time, and withholding of increments, as I said, withholding the increments of salary and promotion of the professional occupation. Demotion, that is, rather than promoting, demoting him to a level down. And termination means removing the employee permanently. In such cases, these punishment are imposed on the type of misconduct which has been occurred by the employee, and in that allegation of investigation, if it is been proved, because sometimes there will be some misunderstandings due to which the employee will be punished, or there will be a charge sheet filed. But if the employee is found not to be involved in any of those allegations, he will be set free of that allegations and etc. So thank you so much for listening this all things.